Hi, thanks for joining us today. My name is Giles Salmond. I'm a partner at Stewarts. I head up the indirect tax disputes practice, and I have over 30 years of litigating against HMRC in all manner of cases, but in particular the financial services.
Hi, I'm Anastasia Nourescu. I'm a senior associate here at Stewarts in the tax litigation and resolution team, and I specialize in high-value complex tax disputes.
Today, we thought we'd give you an update in relation to an important VAT grouping case, Barclays Services Corporation. This is part of a long-running dispute which has followed on from the HSBC litigation, and we're going to give you some of the key updates and what happens next.
As Giles said, this is a short update, and it's aimed mainly at in-house advisors who work in the financial services industry, who are looking to keep up to date with recent tax developments and figure out how those impact their organizations, but also more widely at any VAT or tax advisors with an interest in the financial services sector.
Let's have a look at what we're going to cover today. So we're going to look at the background facts, and then we're going to look at the three issues which the tribunal considered, which is whether or not there was a fixed establishment. They're going to move on to the Danske Bank issue, which is basically whether or not the UK traditionally considers a branch to be the whole entity to be part of the VAT group, or whether it's only the branch. That's the Danske issue. And then we're also going to look at the protection of the revenue, which is an argument which HMRC has raised in many of these cases, including this one.
So let's start off with the factual background. There are two appellants in this case: Barclays Service Corporation, which we'll refer to as BSC. This is a US company that provides services to other members of the Barclays Group, and it has a UK branch that employs 4 people, all of whom had previously worked for other companies in the corporate group, and it has an office in Cheshire. The evidence during the hearing was that the UK branch was involved in monitoring and updating intra-group agreements between BSC and the entities to which BSC provides services, among other activities. One of the companies that receives services from the UK branch of BSC is Barclays Execution Services Limited, a UK company that is also the representative member of the UK VAT Group. Both of these companies are indirectly owned by Barclays plc. In December 2017, Barclays Execution Services made an application for the UK branch of BSC to join its VAT group. A few months later, in 2018, HMRC refused the application for 2 reasons. First, it said BSC was not eligible to be treated as a member of the VAT group because it was not established and did not have a fixed establishment in the UK. Or alternatively, even if BSC did have a fixed establishment in the UK, HMRC thought it still had to refuse the application for the protection of the revenue. The 2 companies appealed, and as Giles mentioned earlier, there were 3 issues in the appeal, actually, because there were 2 limbs to the VAT grouping and fixed establishment issue. First question was, does the UK branch of BSC constitute a fixed establishment in the UK for the purposes of the UK VAT grouping provisions? Secondly, can an establishment outside the UK be included in a UK VAT group, or does the wording of VATA contain a territorial limitation? And finally, if BSC does have a fixed establishment in the UK and there is no territorial limitation, is it right that HMRC could not reasonably have been satisfied that it was necessary to refuse the grouping application for the protection of the revenue? And we'll start off by looking at each of these, and we'll start with the fixed establishment issue.
Thanks, Anastasia. So, as we know, the VAT legislation provides that 2 or more UK bodies corporate are eligible to be treated as members of a group in certain circumstances. The UK body corporate means a body corporate which is established or has a fixed establishment in the United Kingdom. And the question of the fixed establishment is obviously key to this particular issue before the tribunal in this case. So HMRC said it was appropriate for the tribunal to adopt the same approach as HSBC in the upper tribunal, where the upper tribunal said that the fixed establishment was to be looked at by starting with the supplies of goods and services in the place of supply rules. So in other words, is there a fixed establishment where goods or services are supplied by that fixed establishment? HMRC, that in order to establish whether or not there was a fixed establishment, it had to have a real trading presence in the UK and that it was capable of supplying goods or services in its own right, and that the services weren't just merely preparatory or auxiliary, adopting that test from what the European Court had said about place of supply in the context of fixed establishment. And the second point was, has it got sufficient permanent resources to be able to supply those goods and services? And does it have sufficient permanent resources to receive the supplies of goods and services? Barclays' approach was somewhat more straightforward in a way, because it said basically you just have to look at whether or not there are human and technical resources, and those are a much lower test than in the place of supply rules for fixed establishments. Andrew Hitchmu, KC, who acted on behalf of Barclays, said that essentially it was unnecessary for the tribunal to consider whether or not there were human and technical resources in the UK by the branch, and that they were merely making a meaningful contribution to the business of the non-UK company. HMRC said that that was a vague which had essentially been made up and was too vague, but nevertheless, that was the position that the tribunal adopted. So it worked on the assumption, not necessarily agreeing with the test, but it worked on the assumption that Barclays' approach was right, and therefore it began by looking at whether or not on the day that Barclays Services Corporation applied for VAT grouping, it had the relevant human and technical resources. And as an aid to interpreting what were sufficient human and technical resources, the tribunal looked at Advocate General Cocott's decision, or opinion, I should say, in Welmery, where it said that although it wasn't necessary for that fixed establishment to actually own the relevant human and technical resources, it had to have comparable control as if it were the owner over those human and technical resources. Now, unfortunately, on the facts, Barclays failed this test because although, as Anastasia said, there were 4 people employed by the fixed establishment in the UK, on the day of application, the 1st of December 2017, only one of them was actually working on that particular day, although there were contracts which stated that the other employees were to be employed from the 1st of December. But that person that was working wasn't fully engaged in relation to the business of the fixed establishment and was doing quite a lot of work in relation to her old job. And moreover, she reported to her old boss, who was not part of Barclays Services Corporation. And therefore, the tribunal was able to say that the control test in relation to the human resources was not met. And moreover, it said that although there was a place within Barclays' organisation in Cheshire, as Anastasia said, again, there were no evidence of leases or any control that BSC had over that resource, in other words, where its fixed establishment was. So on that basis, it said it didn't have sufficient to say that on the 1st of December, there was in fact a fixed establishment. It's worth pointing out that Barclays said, well, actually, this on the 1st of December was a fixed establishment in its infancy. And it was argued on behalf of Barclays that essentially one should look at the intending trader VAT registration analogy. But the tribunal rejected that on the basis that even if that might be correct, what the entity was doing, what the branch was doing on day one was so minimal as to be simply preparatory or auxiliary, and therefore failed the test which it had adopted based on the AG's opinion in Welmery. which again is obviously a case on place of supply and whether or not supplies are made from a fixed establishment. So it's a bit frustrating, unfortunately, that this case doesn't give us anything more in relation to actually what is a fixed establishment. As we noted, the upper tribunal took a similar approach in HSBC, but at least we have some guidance as to perhaps what isn't going to be sufficient in terms of those human and technical resources, even though we don't necessarily know what would happen at this stage if we did have those human and technical resources.
Thank you, Giles. I'll move on to the second issue in the appeal, which was referred to as the Danske Bank issue. And the question here was, does Section 43A of VAT allow the entire eligible non-UK body corporate into the VAT group, which is known as the whole establishment construction, or does it only allow that part of the non-UK corporate body established in the UK? So it's always been accepted that the whole establishment construction is correct in the context of the UK legislation. However, in this case, HMRC tried to argue that this was brought into question by the CJU's decision in Danske Bank. Some of you may have come across that decision before, but just to recap, Danske Bank had its head office in Denmark and a branch in Sweden, and it applied for the Swedish branch to join the Danish VAT group. The CJU held that due to the territorial limitations inherent in Article 11 of the Principal VAT Directive, the Swedish branch could not be part of the Danish VAT group. The question in this case was, is it possible to interpret Section 43A to impose the territorial limitation in Article 11 of the Principal VAT Directive, as described in Danske Bank? The tribunal here held that departing from the whole establishment construction would have significant practical repercussions for UK VAT grouping, and it therefore held that it was not equipped, in the event it would not be possible or proper for it to give a conforming interpretation to Section 43A. So the whole establishment construction is safe for now, unless this issue gets revived on appeal or in another case. The Treasury did have a call for evidence back in 2020 on the VAT grouping provisions, which included a question in relation to whether establishment-only provisions should be adopted in the UK. But the Treasury decided not to take any action as a result of that call for evidence. This seems to indicate that the government accepts any changes in this area would require careful consideration and should probably be effected by amending the statute. So that being the case, why did HMRC raise this argument? Well, there's a benefit to HMRC of effecting this change through case law, because the new interpretation would have retrospective effect, whereas a law change would likely be prospective. It also helps HMRC's argument that the grouping of foreign entities needs to be considered carefully, as the CJU's approach in Danske Bank helps give the impression that HMRC's more restrictive interpretation to a fixed establishment is to be preferred. So let's see if HMRC tried to take this point any further. So now moving on to the third issue.
Okay, so in the third issue, we're looking at protection of the revenue. I'm pleased to say that Barclays succeeded in defeating HMRC in relation to this. This is a sort of tail end Charlie, I suppose, of HMRC's argument, because obviously it would only come into play had the tribunal found that there was in fact a fixed establishment. The jurisdiction of the tribunal was considered, and again, it followed the HSBC upper tribunal decision on this. And essentially, although it has to look at whether or not it was appropriate for HMRC to implement this particular provision for the protection of the revenue, it didn't need to look at the decision-making process itself, but the result. And in other words, was the result correct or not? So the FTT said that the test involves a balancing exercise in which the commissioners must weigh the effect on the appellant of refusal of grouping against the loss of revenue likely to result from grouping, following the NatWest case. Now, in this particular case, it held that there was no loss to the revenue that goes beyond the normal consequences of grouping. And I think it's interesting to note, perhaps for other taxpayers, that in this particular case, the tribunal recorded that the evidence was that the business had a one-off tax advantage to implementing the branch before year end, and that potentially is why it made the application when it did. And it also recognised that there was a relatively large, it was said to be between £5 and £10 million worth of VAT that would be saved by virtue of having the branch presumably on reverse charge costs from its head office. Now, in the context of a large organisation such as Barclays, that's probably a relatively small amount of VAT overall, but nevertheless, it was helpful that the tribunal found in Barclays' favour on this particular point, and potentially for other taxpayers. But again, we'll have to see whether or not the revenue seek to appeal this particular issue, if indeed the case does go further on appeal. So just to have a look at some of the key takeaways here. So first of all, we know that this is currently the lead case on this particular issue. The upper tribunal had already made a decision in relation to HSBC, as you may know. Permission to appeal that case was refused. And we understand now that HSBC and HMRC have reached a compromise, and so that case won't be heard any further. At the moment, we don't know whether or not Barclays will in fact seek permission to appeal their case, but obviously if they do, then it's likely that HMRC might equally cross-appeal on the points it was unsuccessful, i.e. the Danske whole entity point and the revenue protection point. The other point that's also worth bearing in mind is that I think these cases will all ultimately turn on their own facts. So we have some indication, as I said earlier, as to perhaps what's not sufficient to generate the relevant human and technical resources that are required. But we haven't seen what the position is going to be if indeed there are human and technical resources within the branch. Does that branch need to make supplies of goods and services in its own right? Or is it, as HMRC tried to argue was the wrong approach, but Barclays tried was, does it simply make a meaningful contribution to the business? In other words, its head office. Is that sufficient for it to have adequate activity for it to be a fixed establishment for the purposes of VAT grouping? HMRC, as we saw in the earlier slide, dealt with this question of whether or not what it was doing was merely auxiliary. I think it was said that basically we couldn't have somebody there just literally twiddling their thumb. So they obviously has to be doing something, which is where Barclays said it has to be a meaningful contribution. But the question is, what is that? What does that really mean? And how do we get beyond whether or not that's something that could be merely auxiliary? So we'll give you an update if we hear any more in relation to the appeal. And we will also obviously monitor any further updates in relation to this.
That's all from us. Thank you for watching. We hope you found that useful, and stay tuned for the next installment.
And please do feel free to contact us on the email below if you have any questions or just wish to get in touch with us. Thank you.